Good evening, everyone, and welcome to the second part of our Surveillance and Humanities virtual conference series. I'm Jelena Gligorijevic from the ANU College of Law, and it's my pleasure to chair this session on surveillance and policing. And before we begin today's session, we'd like to acknowledge the traditional owners of the land on which we meet today. We would also like to pay our respects to elders past and present. And before I introduce our speakers for this evening, I just want to note a couple of things about this webinar. We have 3 presentations today, and each will be 10 minutes long, with hopefully 30 minutes for Q&A discussion afterwards. Now, as previously, this webinar will be recorded. Your microphone has automatically been muted and the chat function has been disabled. So to submit a question, please click on the Q&A button at the bottom of the screen. To ask a question, just raise your virtual hand and we will unmute you, but please also do remember to unmute yourself before asking a question. Once again, this event is being recorded, so your display name and any questions you may ask may be included in the recording. So, let me introduce our speakers for this evening. Professor Philippe Sabot joins us from Lille University, where he is Professor of Contemporary Philosophy and Human Sciences, specializing in ethics and society. He is president of the Michel Foucault Center, in whose work he specializes, and he is also a translator of Judith Butler's works. One of his major areas of work is on the application of Foucault in contemporary studies, and he regularly advises the Lille University Research Hospital on end-of-life questions and care and vulnerability in medical and social contexts. And Professor Sabot will be talking about his work on surveillance and its ambiguities, given there are both desirable and problematic forms of modern surveillance. Professor Grabosky is Emeritus Professor at the ANU, and his interests lie in policing, cybercrime, and abuse of state power. He was president of the Australian and New Zealand Society of Criminology, and he co-wrote a book together with Gavin Smith and Gregor Urbas, Cyber Criminals on Trial, which in 2006 won the Outstanding Book Award of International Criminology at the American Society of Criminology. Gregor Urbas is currently an adjunct associate professor at the College of Law and a practicing criminal barrister. Dr. Urbas is internationally recognized for his expertise in cybercrime, forensics, and intellectual property enforcement. Professor Grabosky will be talking about his work with Dr. Urbas on how private and public actors undertake surveillance, particularly covert online investigations. Georgiana Banita is a research professor at the Timberg Research Academy of the University of Bamberg. One of her major works, Plotting Justice, Narrative, Ethics, and Literary Culture After 9/11, was published in 2012, and she co-edits volumes on American electoral cultures, gender and mobility, and the comics of Art Spiegelman. She is on the editorial board of the Journal of American Studies at Cambridge University Press, and in her role there, she is presently editing a special issue on race and predictive technologies in US culture. And Professor Banita will be talking about her work on critical narratives of race and predictive policing and how Black futures matter in that context. So, without further ado, I will hand the screen over now to Professor Sabot.
I wish to articulate in this talk several possible approaches to the problem of surveillance. They are inspired by a Foucauldian and post-Foucauldian conceptuality, and I'd like to confront this conceptuality with some challenges of our times. First, and fundamentally, there is what I would describe as ambivalence in our relationship to the very idea of surveillance. This ambivalence concerns the articulation between freedom and security. The very notion of surveillance was developed by Foucault in Discipline and Punish as the correlate of a disciplinary society. It is rooted in the dimension of an anatomopolitics, that is, the control of individuals, of their distribution and movement in space and time. What prevails here is the need at the time of the development of industrial capitalism to shape docile and productive bodies and subjects whose activity is oriented towards the optimization of gestures or inter-individual relations on a production chain. But this making of disciplined subjects extends throughout the entire society, and its means of control and optimization of conduct: school, factory, hospital, prison. Surveillance thus translates a constant and fine attention to deviance of all kinds, and at the same time it builds the knowledge that makes it possible to effectively correct these deviance by measuring them against a standard, a norm, previously set and fixed in scholarly discourse, regulations, laws. Surveillance is the technology bias of a disciplinary society. The type of control it provides is oriented towards correcting deviations from the standard, from the norm. In this perspective, such individual control with a normalization aim can legitimately appear as an infringement of our freedom and of the recognition of the equality of citizens. The economy of surveillance draws a distinction and a hierarchy between the useful and the useless. It leads to the distribution of subjects into good and bad subjects. Surveillance is thus given as the paradigm of a power that sorts, selects, distributes, corrects, and in any case makes the norm to be reached or respected prevail over the freedom of individuals. From another perspective, however, the occasional and controlled attack on the freedom of some people may also appear to be a guarantee of security for all. Here we have another side of surveillance, which refers to the stakes of biopolitical management of populations or the governmentality of the living. It is no longer the individualizing, normalizing dimension of surveillance that is at stake. It is its regulatory dimension. Control functions in support of a demand for security. It is also another purpose of surveillance that is emerging. The surveillance, which supports the management of populations, finds its principle in what Didier Fassin calls biolegitimacy. This biolegitimacy refers to the valuation of life as an ethical norm of public action, particularly in the medico-social field. In epidemic times, the demand for surveillance increases, not only on the part of public authorities, but also on the part of individuals. There is a demand for surveillance that protects populations, including against themselves by restricting their freedom of movement, lockdown, for example. In this way, surveillance shifts its strategic point of application. It will focus on epidemic curves, on the foreseeable impact of the health crisis in order to regulate its medico-social effects, and in particular to better control and manage access to healthcare. What we are controlling and monitoring is no longer individuals directly, but a relationship between healthcare capacities and the spread of a virus within a population. Surveillance in the era of biopolitics thus becomes one of the cogs of a sanitary reason. It is the instrument for exercising and implementing public health policy. It is understandable why there is ambivalence towards such controlling devices. There is fear and criticism of the deployment of increased surveillance devices, which jeopardize individual liberties, for example, lockdown and digital tracking. But at the same time, there is an appeal to public authorities to control the circulation of the virus. At another level, this ambivalence in a relationship to surveillance is no doubt linked to a deeper ambiguity in surveillance itself, due in particular to the development of digital tools and networks. I will mention just 2 points on this subject. First, I'd like to underline the ambiguous relationship between a surveillance society and a society of self-exposition, as described by Bernard Harcourt in his essay Exposed. In reality, the society of exposition is undoubtedly the new form taken by the surveillance society, if by this we mean what Deleuze called societies of control, taking over from what Foucault had described as a disciplinary society. In such societies, individuals are more free in their movement, in their appearance, in their sexuality, than in the disciplinary greed and the corrective punishment of their actions. But control continues to be exercised over them. It is just more flexible from a distance through devices that address the motivation of the individuals themselves and which are the more powerful as they are based on the desire to participate in this vast movement of self-exposition. The surveillance society, as Deleuze prophesied, is moreover strengthened by the development of digital technologies and this aspiration of each individual to become a digital self. The renewal of surveillance society into a society of control is thus driven by the contemporary desire to expose oneself beyond the fear of being watched. A new form of subjectivity is being shaped by contemporary uses of digital technologies. These uses make us increasingly transparent, blurring the boundaries of public and private. We arrive at a new formulation of the previous ambiguity. The new regime of surveillance of digital beings that we have become is based on this desire for unlimited exposition that confers on everyone a digital transparency, seen both as a refuge of the greatest freedom and as a vector of an increased vulnerability. This is the flip side of continuous self-exposition on social networks, for example. Surveillance evolves according to this new individual and social situation. We are witnessing a progressive deprivation of intimacy, which is less the deliberate effect of a certain exercise of power, and in particular of state power, than the new regime of truth in which contemporary subjects install themselves in order to exist. As Bernard Harcourt says, we are not watched, we knowingly expose ourselves to the protocols and devices of surveillance. Last point, on the political and social level, it is possible to extend this point or to update it. We are witnessing the transformation of a surveillance society into what we call an algorithmic governmentality, and its daily translation into what the philosopher Antoinette Rouvroy called a society of profiling. We are no longer talking about controlling our desires in order to contain or to correct them. Rather, it is a question of defining the general profile of our behaviors to see how they can converge in a kind of social optimum where probabilistic risk management prevails over the coercive assignment of subjects to disciplines. In this perspective, a new articulation between control, security, and freedom appears, which is marked in particular in the kind of convergence between the digitalization of our existences and the entry of punitive practices in the virtual world. According to Rouvroy, it is now possible to profile offenders, to calculate the probability of recidivism in order to decide on the nature of their sentence and its execution. That is, in an open environment with an electronic bracelet or in a closed environment. So algorithmic governmentality defines a new modality of decision support. It puts our decisions, our individual, legal, social decisions under surveillance. I've finished.
Thank you very much, Professor Sabot. Right, so as I said, we'll leave questions and discussion to the very end. So I'm going to go directly hand the screen over to Professor Grabosky now.
Thank you very much. Can you hear me all right? Okay. Our article on which this presentation is based, Gregor and I look at undercover policing of child exploitation and private third parties or cyber vigilantes as co-producers of online child protection. We begin today with a discussion of state actors on two dimensions. First, police impersonating children or adult facilitators online, Second, police secretly seizing, control, or otherwise compromising an offending computer or website that contains images or vision of child abuse. They do this in order to make a case against suspected pedophiles. Now, both of these scenarios have analogs in the policing of physical space, and I refer to the work of Gary Marks, his landmark book, Undercover, in which he discusses decoys, controlled deliveries of illicit drugs, and contraband generally, police operating as receivers of stolen goods, etc. Now, in the United States, various irregularities can occur in the course of a police investigation. It can be a lack of a warrant or defects in a warrant, insufficient specification of time, place, subject, etc. The issue of entrapment and unconscionable police conduct more generally. And in the United States, this can lead to the exclusion of evidence or dismissal of the case outright. In Anglo-Australian jurisprudence, by contrast, there's no defense of entrapment. However, a trial judge may exclude evidence that has been illegally or otherwise improperly obtained when concerns for the integrity of the judicial process outweigh the public interest in convicting the guilty. The regulation of controlled deliveries in Australia was inspired by the Ridgway case in 1995, in which the High Court quashed a conviction following the illegal importation of heroin by police. Now, later, we'll look beyond the activities of police to focus on the democratization of digital technology and how it's placed powerful investigation tools in the hands of ordinary citizens. And we asked the question, what protections exist for the accused whose prosecution is facilitated by the illegal collection of evidence by private persons? Well, let's begin by looking at two cases involving questionable investigations by police alone. First, the Solomon case, which is a case from the state of Washington, arising from an investigation commenced in 2014. In this, a female detective made online contact with a male through a Craigslist site that is open to persons aged 18 and over. After some suggestive exchanges, the detective announced that she was 14, almost 15, to which Solomon replied, I'm not willing to get into trouble. Maybe hit me up in 3 years if you're still around. I take everything back. I'm not interested at all. This is a setup by cops or a website. Good luck to you. Well, the detective persisted with her overtures to the extent that Mr. Solomon sought to withdraw from the interaction on 7 different occasions. The detective persisted, and her seductive overtures prevailed in the end. In the paper that I have, and I'm happy to send a copy to anybody who might be interested. There's a link in a footnote to the transcript of the detective's exchange with the suspect, and it was indeed seductive. The overtures were so extreme that the trial judge dismissed the case for outrageous conduct, and the appeals court agreed. Next, we move to the playpen cases. In 2015, the FBI arrested the administrator of the Playpen, a child pornography internet bulletin board on the dark web. The FBI immediately took over administration of the site and operated it very efficiently for 2 weeks. They quickly obtained a warrant to install what is called a network investigative technique on the Playpen servers. The technique basically was malware that allowed the FBI access to the computers of Playpen users, regardless of their location in physical space. At least 22,000 pictures, videos, and links to child pornography were downloaded during the period of FBI administration. Thus, according to conventional counting rules, agents committed no less than 22,000 offenses in the course of their investigation, if every download is a crime. So at least 22,000 pictures, videos, and links to child pornography were downloaded. And the question arises, was this a case of a disproportionate state response? The case that we cite, which is United States versus Kim, the defendant, Mr. Kim, claimed that This constituted outrageous police conduct. After all, 22,000 crimes. The FBI, however, maintained that its agents regularly assessed the continued benefits of the investigation. They shut down the website as soon as the investigation concluded. They continuously monitored postings to the website and took immediate action where they determined that a child was in imminent danger. And they contend that 49 children who'd been subjected to abuse were rescued, rescued or identified as a result. And the FBI then claimed that the benefits of the operation outweighed the costs. Well, the court wasn't terribly concerned with the FBI's argument on its behalf, because the court held that whatever the conduct entailed, Mr. Kim's rights were not violated by the downloads. And the prosecution dealt with Mr. Kim and his rights as a suspect. And the alleged impropriety on part of the FBI related to individuals other than Mr. Kim. In Australia, the Queensland police have authority to engage in such investigative practices, that is, committing what would otherwise be criminal acts in furtherance of an investigation. Under their legislation, the Police Powers and Responsibilities Act of 2000. It requires judicial supervision and provides indemnification for crimes committed by police. Task Force Argos, which is the branch of the Queensland Police that does this kind of work, has received international recognition for its investigations based on the covert management of illicit websites. Indeed, a number of overseas jurisdictions have sought to collaborate with the Queensland Police in order to benefit from the latter's relative lack of restraint. They can piggyback on Queensland police engaging in activity that would be inappropriate for them to do in their home jurisdictions. Well, the question arises, what of private vigilante activity? What about uncontrolled operations? And we talk about three particular cases there, Steiger, Jarrett, and Klein. These are US prosecutions. Three cases arising from illegal hacks by private citizens or wannabe cops into personal computers through malware introduced into chat rooms frequented by suspected pedophiles. In each case, the hackers notified the police either directly or through an intermediary and disclosed the identity and contact details of the alleged pedophile. The police then commenced investigations and convictions followed. In each case, the defense argued unsuccessfully that the hacker was an agent of the state and that the evidence conducted as a result of the illegal private search were inadmissible, as would normally be the case in US police searches. The courts, however, held that some degree of government knowledge of and acquiescence in the search before the fact is essential for the private party to be deemed a state actor. And that was not the case here. I should also mention that in each of these cases, the wannabe hacker was resident outside the jurisdiction of the United States. In two of the cases, Steiger and Jarrett, the informant was claimed to be in Turkey, whereas in the Klein case, the wannabe cop was in California. In any event, the US authorities were not interested at all in bringing them to justice for their illegal acts. They were quite pleased with the services that had been rendered. Well, reliance on or encouragement of online private vigilante activity raises a number of issues involving unintended consequences. It may invite crime through the enhancement of supply or demand for illicit products or services. The motives of the vigilante may not be purely altruistic. In one case from the ACT, 4 juveniles used social media to lure gay men to engage in underage sex, then demanded extortion payments. One of the extortion victims took his own life. One of the juveniles professed what the judge rejected as a self-serving sense of vigilantism, and basically argued that the judge stated that any form of vigilantism tends to undermine the rule of law and divide what is otherwise a tolerant community in the Australian Capital Territory. it is abhorrent to the public. Another issue, of course, is the risk of interference with police investigation. And in one case in Adelaide, the senior South Australian detective was quoted as warning, "It is not appropriate for individuals to take matters into their own hands because no matter how well-intentioned they may be, this can significantly obstruct and hinder what police are empowered to do." And in that recent South Australian case, both the alleged pedophile and the vigilante were prosecuted. So in conclusion, Gregor and I asked, are there limits to utilitarianism in the investigation of child protection issues? Should not suspects be protected from the excesses of private citizens no less than those of the state? And even if it's regarded as necessary to do evil in order to achieve good, query whether at the cold face it may be too easy to underestimate the degree of evil required and to overestimate the potential value of the outcomes we seek to achieve. And if you're interested in these issues, I would encourage you to consult today's issue of the New York Times, which describes the practice of detectives in the state of Washington in the United States and some of the unfortunate outcomes that can result from practices such as these. Well, thank you very much.
Thank you, Professor Grabosky. So I'll hand the screen directly over now to Professor Banita.
Thank you so much. So I'll dive right in. The starting point of my talk are policing measures aimed at preempting Black violence in particular. These measures range from Terry stops and the chokehold to predictive algorithms to target hotspot areas in minority neighborhoods and individuals with links to known criminals. I regard the effects of these measures as a whole to describe what may be called pre-crime racism. We are used to recognizing racism in the way the criminal justice system treats people of color. But what I want to suggest is that racism begins earlier, namely with the expectation that a Black or a brown subject is likely to commit a crime, an assumption that underwrites all of the above policing measures. So first I want to define the concept of pre-crime racism as a basis for my discussion of critical narratives around racialized predictive policing. Then I address scholarly, artistic, and quotidian forms of resistance to surveillance and algorithmic bias, some of which propose more visibility and therefore more accountability for the police, while others advocate for making Black lives opaque and illegible. In other words, for withholding information about Black citizens from the machines of social control. Adjudicating this debate would take more time than I have at my disposal today, so I will just briefly conclude by invoking the COVID-19 crisis as a potential touchstone for a discussion on data visibility and race going forward. So what exactly is pre-crime racism? I think it falls into two large categories, subjective and systemic. Let's begin with the subjective forms. They denote those types of citizen police encounter that involve individual people of color and individual law enforcement officers. This kind of predictive racism draws on the personal prejudices of cops who make split-second decisions about who might be a good suspect. Terry stops, either stop and frisk or traffic stops, describe situations in which police can detain a person based on a reasonable suspicion of involvement in criminal activity, which is a lower standard than the probable cause needed for arrest. The unwarranted Terry stop has, of course, become a cliche in the representation of police bias. It is invoked by musicians from Johnny Cash to Jay-Z. It is a source of hilarity in American comedies and has entrenched the idea that criminal suspicion can arise in the absence of knowledge about circumstances and that it is often based on physical appearance. Then there's a chokehold, that is the restriction of air or blood flow passing through the neck. In law enforcement, its aim is to force an uncooperative suspect to cease resisting and to do so without causing death or permanent injury. As the killing of George Floyd has shown, a prolonged chokehold highlights the danger of putting too much weight, literally, on the supposedly impending danger of Black crime. After all, the officer continued to press his knee against Floyd's neck despite the fact that Floyd was clearly incapacitated and unlikely to pose a threat. It is important to recognize the pre-crime racism underpinning these techniques of crime prevention because they help us understand exactly what kind of racism we're dealing with here, one based on projection, anticipation, and fear. Moving on to systemic forms of pre-crime racism. They go beyond the systematic promotion of subjective tactics. Rather, they create a criminological consensus by collating big data and processing past criminal activity into indicators for future crime. Broken windows policing already counts as a form of pre-crime racism to the extent that its logic assumes small-time criminals inevitably evolve towards more serious crimes over time. Predictive algorithms take this logic one step further by describing the future crime, retroactively labeling the Black subject a criminal in the making. And what is predictive policing? To put it simply, it is a digitally driven patrol strategy that seeks to prevent future crimes by focusing on repeat offenders or those suspected to potentially commit a crime in the future. From Los Angeles, Chicago, and New York to police departments in France and New South Wales, algorithms have increasingly superseded conventional policing in ways that arguably help develop, maintain, and expand a digital underclass of docile Black subjects. Software like Predpol, Beware, or HunchLab build on routine activity theory to map repeat behavior in order to identify a crime event before it occurs or to nano-target potential criminals. Troubled by this development in law enforcement, scholars like Ruha Benjamin, Simone Brown, and Sophia Noble have exposed and denounced the ways in which putatively objective predictive technologies in fact risk perpetuating racial prejudice. New forms of racial profiling that Sophia Noble has termed technological redlining consolidate existing biases and inequalities while formally appearing to operate race blind. Recent scholarship by Ruha Benjamin about what she designates the new Jim Code has additionally proven the benefits of tracing present algorithmic tools back to past techniques of promoting racial discrimination and white supremacy. Because predictive softwares do skew towards African Americans and Latinos in the US, Blacks and immigrants in Europe, and young Aboriginals in Australia. These methods of racialized prediction have brought forth different kinds of resistance, and I will focus here on only 3 such examples. The first is the so-called Black Data movement, which aligns critical race theory with cryptographic and anarchist activism. The Black queer scholar and artist Shaka McLaughlin has suggested that, I quote, Black bodies, and especially Black queer bodies, are understood as data points, statistical objects, or deviations, rather than as ontologically material persons. In response, McLaughlin suggests a range of tactics, from covering one's face to undermine surveillance, to the creation of a Black web of data in the service of, rather than detrimental to, Black lives. A second form of criticism has been dramatized in documentary work about pre-crime systems and their immediate effects on Black suspects. The focus here, for instance, in a German documentary called Pre-Crime, has been on the self-fulfilling prophecy effect, namely the tendency among African Americans in the USA and BAME persons in the UK to react to the suspicion created by machines by conforming to the expectation placed upon them, rather than acting in the opposite direction. And most prominently, of course, it is the Black Lives Matter protests that have drawn attention to the labeling of Black lives as potentially criminal. The slogans have focused on the idea that Black lives are especially valuable because they are exposed to additional risks. The symbolism of breathing under the chokehold contributes to this argument. But the demonstrations have shown that the logic of predictive policing can be turned on its head. If officers have killed this person, they will inevitably go on to kill others and must be stopped by preemptive action, such as defunding the police. Whether directed against surveillance and high-tech policing or the casual racism of the police of individual police officers and the systemic racism of law enforcement in general, the critiques I just outlined argue and act out against the racial determinism of crime. Critics of pre-crime measures insist that race and its proxies, such as postcode or income, cannot predict anything, as the prediction algorithms rely on biased indicators based on police data that is itself far from fair. And yet, in the aftermath of the COVID-19 pandemic, some advantages of racial, or I should say, racial and social determinism have come to light. Black people have been disproportionately affected by the pandemic. The health outcomes for Blacks and Latinos in the US, for instance, have been devastating. Based on the risk factors that attach to people of color on the basis of, for instance, unemployment, poor healthcare, and being a significant part of the group known as essential workers, important numbers can be crunched as data for Black lives, namely data that seeks to extend Black life in freedom rather than anticipate and thereby shape Black lives behind bars. Black futures matter, of course, to the extent that they remain invisible, out of sight and foresight. But the protection of Black rights depends to some extent also on the causal factors that curtail those futures. What the present health and policing crisis calls for, I think, is a new kind of prediction for rather than against Black lives. Thank you.
Thank you very much, Professor Banita, and thank you indeed to all three of our speakers. I thought that went very well, those presentations, and I know how tough it is to limit your time to just 10 minutes. So that allows us plenty of time for Q&A discussion. So as I said before, if you've got a question, please either just raise your virtual hand or you can type in the Q&A function. And I can already see that there's one question or comment in the Q&A from one of our attendees, Joe. So what I'm going to do is I'm going to unmute you, Joe, and if you want, you can say your question out loud. I believe that's to Peter Grabosky. So I've unmuted you, and hopefully you will be able to unmute yourself and present your question.
Okay, am I coming through?
Yes.
Brilliant. Okay, so my question was for Professor Grabosky. It was a great presentation and thank you for it. I enjoyed all the speakers. In the United Kingdom, we've seen a rapid rise of online child sex abuse activism by so-called paedophile hunters. It's something that I've been interested in for a while. It's an area that's quite challenging because these groups have definitely embodied some of the risks that Professor Grabosky outlined, but some of these groups try to adhere to the law and have undoubtedly had some successes in helping bring repeat and dangerous offenders to justice. So I just wondered if Professor Grabosky had any reflections on how the police should respond to these groups, whether or not there's scope for citizens, well-meaning citizens, to work with the police and perhaps be a useful resource to the police, and what sort of form that might take, if any.
My colleague Gregor might want to contribute to this response as well, but I remain focused on the risks of contagion, as it were, and the risks that many people who might join in the citizen enforcement might do so either irresponsibly or maliciously, and I'm terribly concerned about the risk of creating a nation of informants for good or for evil. I would imagine that that some kind of systematic analysis by law enforcement might be able to shed light on the merits or otherwise of mass participation, as it were, in these types of investigations.
So just if I can add to what Peter said, I think one of the interesting things about the United Kingdom situation is that there's almost a market failure initially with the UK police's abilities to investigate online child grooming. It depends on the legislation that defines the offence. For example, the legislation in Australia creates the offence of child grooming where the person being contacted is under the age of 16 years or is believed to be under the age of 16 years. And it's deliberately written in that way to allow for the full offence to be committed even when there's no actual child. So right from the beginning of the legislation being enacted, the possibility was consciously envisaged that there would be the use of fictitious identities in investigating these kinds of crimes. As I understand it, that wasn't the case when the similar provisions were enacted in the UK around 2003 following the Studebaker case. And so that left the police with a lot less power to investigate these things in a covert and what you would say proactive manner. And then it fell really to members of the public to fill that void by conducting their own sorts of vigilante operations. And I think that's part of the background to it. So it's an uneasy balance between public and private, and it depends on the way the legislation is structured.
Thank you, Dr. Urbas. Is there something you wish to add, Joe or Professor Grabosky?
No, that was great. Thanks, guys.
Right, excellent. So I've got a question from Anne Brunon-Ernst, co-organizer of this conference. So I'll hand over to you, Anne.
Okay, thank you very much to our three presenters today. Really extremely fascinating talks, and I really would like to thank them for that. I don't have a question, I have a comment that I'd like to make, but if anyone else wants to react to my comment, you're most welcome, but they're not phrased as questions. Now, I'll start with Professor Grabosky's and Urbas' presentation, and the way in which I found that there was a link there between Professor Sabot's talk and their presentation of how covert investigation was reusing or playing on exposure online and twisting it on its head in order to facilitate a criminal investigation. So the way in which this society of self-exposition, as Professor Sabot explained, was in fact there, twisted upon its head in order to facilitate a criminal investigation. What I also wanted to highlight is the comment that Professor Grabosky made about the issue of supply and demand, and something that hasn't necessarily been apparent in the three presentations, but which maybe is one of the underlying factors of our discussion today, the issue of economics and capitalism that runs through the way in which people actually use surveillance. That's maybe what I would call an open-ended question. I had also a comment to make about Professor Banita's presentation with the issue of predictive software and the extent to which Michel Foucault's biopolitics, in fact, and the use of statistics to regulate large numbers of people is in fact underlies the use of algorithm, which are an automated way of making statistic work within a computer-assisted environment. That's it. Thank you very much.
Thank you, Anne. Do any of our speakers have comments in answer to Anne's comments?
Yes, just a little comment. Thank you for the remarks. I think the major point today is that there is no longer a single central reference for monitoring with social works, social networks, for example, and we have seen this with the child pornography, etc. I think everybody controls everybody, and that's a sort of vicious circle, but also an ordinary way of surveillance today. So I think we have switched from a point of view, a central point of view, with a state power that is monitoring the people to correct them, to contain their desires, and so on, to a point of view where with the social networks in particular, the surveillance is everywhere, and we accept to expose oneself and ourselves, and we accept to be watched about what we expose. So there is a paradoxical way to be watched and watch the others, and I think this is a problem for the child abuse that Peter Grabosky talked about. So that's my comment.
Thank you, Professor Sabot. Do any of our other speakers, or indeed Anne, have?
Yeah, I'd like to add something, if I may. The difference, I think, between Foucault's biopolitical control and contemporary predictive policing is that with Foucault, there are human agents on both sides. So there is a sense that a social agent is attempting to control and regulate and normalize, whatever you want to call it, another social agent. One of them being a minority, like a small minority, and the other one being a larger mass. With predictive policing in the present moment with algorithms, this human factor has been removed, or at least has been ostensibly removed. The decision-making has been confined to the realm of statistics and mathematics, to the point where the one making the decision is ultimately the machine, the so-called prediction machine, and not a person trying to impose a certain political norm over society. And I think this is unsettling, is what I would call it, because it takes away, first of all, the complexity of human decision-making and the ability to think in nuances and shades and adjudicate on an individual basis. Because when a machine makes a decision, informed, of course, by information and models put together by human beings, when a machine makes a decision, it is very difficult to then attribute that gesture of control to a particular agent that can be held accountable for the decision that was made. And I think it is creating new problems in the way that we define artificial intelligence and in the way that we refer attributes we associate with human beings, for example, race or belong to a certain social group and so on. The way we refer to these attributes in relation to artificial intelligence. Can we have something like a Black decision-making machine that can include everything that means to be Black as a person, with all the factors that go into deciding one way or another, right? But at the moment, artificial intelligence operates allegedly race blind. So it's trying to make objective decisions, which is certainly not the case. And the tendency at the moment in order to remediate this problem has been to include a lot of minority and especially Black and brown programmers in developing artificial intelligence for predictive purposes. And it remains to be seen what this will result in ultimately. Any improvement.
Thank you, Professor Banita. And Professor Grabosky or Dr. Urbas, do you have any comments?
Well, it just does seem to me that that human judgment is not infallible either, and obviously the patterns of discrimination enforcement, patterns of discrimination in enforcement are as real and as objectionable as are patterns that are generated through algorithms. I'm at a loss really to think that, for example, the use of decoys, be they for to arrest clients of sex workers or whatever, are going to produce outcomes less just than those generated by a machine. I mean, biases can arise from human judgment no less easily than from algorithms.
Of course, yes. And algorithms are made by people, and they reflect the biases of the people, well, I should say of the sociological theories that are inscribed into them, theories that are put together by human minds. And part of the reason why algorithms are actually interesting is that they can help redress some of those biases, right? In an ideal world, they can be made to identify potential moments of discrimination, of prejudice, and act against those. But as they work at the moment, and they don't work very well, right? I mean, they aren't actually as implementable as people were hoping them to be, and they continue to discriminate and so on and so forth because they're based on biased police data. But as they work at the moment in the present world, they aren't actually an alternative to human decision making. And maybe in the future, there is a way to find this middle way between a perfect machine and an imperfect human decision making agent. And at the moment, I don't think it's possible. And probably in the short term, these predictions are going to be used more rarely rather than more often because their failures are beginning to come to light.
Of course, the other issue is one of mistake, that is false positives, not necessarily a question of bias. And a lot of policing involves perceiving and following up on anomalies. If you see something that looks out of place, that might lead to a thread that could unravel, an entire criminal conspiracy. So that too is something that can work either way, justly or
yeah. Yeah, but this moment when a police officer decides this looks suspicious to me, so I'm going to stop and frisk or interfere in some other way, this moment is shaped by past experience of policing certain neighborhoods, of considering a particular type of suspect to be more likely to commit a crime. So bias is really everywhere. I mean, it is something that I don't think can be removed from any any equation. The question is, how do you work against it? How do you program against it? Be it on the individual level or more systemically.
Well, I believe it was Harcourt himself who spoke about the use of random selection or randomization as opposed to targeted selection of whom to pull over on Interstate 95 between New York and Washington.
And Dr. Urbas, do you have anything to add to that?
No, quite happy for Peter to take the fall on that.
Right. All right. I've noted that Desmond Manderson, who's also a co-organizer of the conference, has a question. So I'll hand over to you, Des.
Just unmute myself here. So, I mean, I think that this difference in the papers is already sort of come out, but perhaps it's worth just focusing in on it for a little bit. And that's to say, it seemed to me that the last two papers treat these stories about policing largely as a kind of an externality. So it comes from, you know, like overreach from police or systemic racism or individual racism that is distorting or corrupting the system. Whereas I think in Philippe's paper, the problem goes deeper or in a different direction. That is that he's talking about a shift in the normative basis on which we make these decisions altogether, rather than a kind of a distortion or corruption within established norms. And so Philippe's point about the rise of the risk society and the rise of the language of security implicates all of us in the way in which these kinds of policing things may seem to be entirely legitimate or necessary. And so I think he's talking about, you know, it seems to me, and Philippe can, you know, say whether I'm right or wrong, I guess, it seems to me he's talking about a shift in the normative paradigms. And I wonder how the normative assumptions of the second two speakers sort of hold up against these really quite profound, at least, you know, Foucault and the post-Foucauldians thinks pretty profound changes in the normative landscape of what it is to be a human, what it is to be free in a society. And, you know, even in relation to the pandemic, we've seen no one is talking, or in fact, by and large, epidemiologists are not talking about random stopping and searching, and they're talking precisely about profiling, about targeting areas, about targeting groups, and the arguments that are being used to defend that sort of profiling are exactly about the importance of risk management, the problems about probabilistic analysis of the world, the necessity for maintaining and protecting security at all costs. All of that kind of discourse is exactly what kind of underpins that kind of language. And that normative shift seems to me something which stretches right through society and through all of our understandings, rather than just being a kind of an unfortunate wrinkle or error that we're making when we allow bias to you know, like rear its ugly head or something like that.
Thank you, Des. Yes, and if I might add, maybe a combined factor of this normative shift is exactly that which Professor Sabot mentioned, this self-exposure that we have for some time now become acclimatized. And it's, I think, entered into the normative sphere that everyone is happy with or has impliedly consented to some form of self-exposure because of the use of technology or social media. It's actually part of the normative underpinnings of what the state may permissibly do to us. I don't know whether, Professor Sabot, you have a response to that, or indeed any of the other
Yes, thank you for the comment. I think the shift from anatomopolitics to biopolitics is very important for understanding who we are and where we are today. I think the norm is very key point. The norm no longer functions in the same way. It is in a disciplinary society a prior reference for correcting individual behaviors, and now in our times it is more a dimension of the regulation and the government of the living, in which individuals actively participate. So this participation in the normalization is very important, and I think it is the major change, very important to understand our time with the development of digital technologies and so on. So this desire to participate, this desire to have to have a place to exist in the social and digital world is the main change for our times.
Indeed, yes. And maybe from your own perspectives or the perspectives of the work that you've done, do our other speakers want to add to that, to answer Desmond's point?
Can I say something very, very briefly?
Yes.
Yes, I was fascinated by Professor Sabot's presentation because it provides such a solid base for my own arguments and for the perspective that I'm taking. And I feel obliged to make a point here about the society or the culture of exposure, because I think it clashes in many ways with another contemporary social movement, that of identity performance or identity cementation, solidification through performance. So when you have Black people going online in order to create a community for themselves, in order to make make themselves seen and heard, and surveil themselves in a very different way, not for control, but in order to but in order to have a greater purchase of their own identity and their place in society. When they go online and they expose themselves in that way, they inadvertently, I would say, feed the machines of surveillance that are then targeted at them. And I think this is a conflict that has to be considered, even practically, when the police is using drones hovering over Black Lives Matter protests, right? I mean, this is a form of expression of a free political congregation and opinion and political participation. But at the same time, it is exactly this democratic way of public participation that is being instrumentalized as a form of political control or of social control. So I feel that it always depends on what kind of demographic we're looking at when we make these broader statements, because not everyone is affected the same way. Not everyone is exposing themselves with the same consequences, I would say.
Yes, and I've just seen Des's point there that he makes, that's exactly Angambon's point. I mean, I agree that self-expression is becoming implicated, and our ability and liberty to express ourselves is implicated in the way in which surveillance is used to control. And I think that's also a great part of how privacy might be affected and implicated in these normative shifts. Professor Grabosky and Dr. Urbas, do you have anything to add to that question or comment?
No, except that infiltration of various groups of ostensive wrongdoers or people who might be up to something is by no means unique to the digital age. I mean, the South Australian police had files on divorce law reformers in South Australia back in the 1960s and 70s. And so what we're seeing now is simply, I guess, a larger stage, another dimension, another medium in which these time-honored tactics of surveillance and repression can play themselves out.
Indeed. I'm aware we've got about 10 minutes left for the scheduled time, and I wonder whether I could put a question in, or my own comments, which arose during Professor Sabot's presentation, but obviously was carried on through in what was said in the other presentations. And that's really about the boundaries I'm concerned with, more governmental surveillance and control, so public or policing, and the shifting boundaries of that, of the permissibility of how much the government can do. And Professor Sabot mentioned biolegitimacy. And my question, or my concern is, well, at what point do we hit the limits of biolegitimacy in terms of individual freedom? Does the concept of biolegitimacy, by virtue of its nature, the intent to contain a biological risk which might affect us all, does that expand the scope of the government state to use surveillance powers beyond what is normally the case? And implicated in that, I think, is the fact that it's normally the state or governmental apparatuses that determine when we enter a state of emergency, for example. And therefore, they can reach to biolegitimacy in order to legitimize increased surveillance. And not just through law, to make it legitimate that degrees of accountability through media, through the law, judicially, might be reduced, might become more palatable to us to cope with increased surveillance and control and controlling measures of discipline in society. So I wonder whether you have a comment about how we might draw the boundaries of biolegitimacy, given the nature of that concept, if we are working against the backdrop of a liberal state, a liberal society, where the state has limits on its powers.
Thank you for the question. It's a difficult question. I think biolegitimacy, in the sense of Didier Fassin, is a paradoxical notion because on one hand, this biolegitimacy refers to a sort of ethical universal norm to protect the living beings, and it's a reference for claiming we are alive, we are living, and we deserve to be well treated. But in a second part, this concept masks a logic of differentiation between lives that matter and life that not matter, or that less matter in the public area. So I think the concept is very interesting because Foucault didn't think the power distributes the lives, and Fassin insists about the idea that the state, the healthcare, for example, make a differentiation between several lives, and we have seen this point in the treatment of epidemic state in France or in all the countries, because there was some selection of good or bad patients, selection of vulnerable lives and not so vulnerable lives. And I think this notion of biolegitimacy is a key point to think about not only the effect of a surveillance state, but also the effect of hidden logic that is at work in the treatment of populations in general.
Thank you for that answer. Does anybody else have, from the panelists, anything to add to that? Right. I think I'm going to call it an evening with that. Thank you all very much for attending, and thank you in particular to our three presenters and Dr. Urbas as well. Each of your presentations I found very stimulating and illuminating on what has become an incredibly important topic in all respects in our lives today. So thank you very much. I would be asking for a round of applause if we were in more normal circumstances, but I'm sure that everyone else shares my appreciation for your partaking in our discussion this evening.